The Senate will please come to order. I'm pleased to welcome for today's devotional exercise, Reverend Jill Colley Robinson, Vermont District Superintendent for New England United Methodist Church of Burlington. Welcome, Reverend.
Thank you. Good afternoon, everyone. It's a privilege and a joy to spend a moment with you. On any given day, you make decisions that potentially have a profound and lasting effect on people's lives and on the natural world we call home. You make decisions about issues that seem insignificant and mundane at the time and that have unbelievable and unforeseen consequences. You make quick judgments on things you know potentially very little about and maybe care even less about, but that matter deeply and dearly to someone, somewhere. You wait and hope and wait some more for the right time for your task to be accomplished. You make choices between bad and worse, or better and best, trying to do the least amount of harm and the most amount of good. You listen to each of the informed arguments and remain unsure about the best path. You compromise in order to make incremental and slow changes. You vote on something that's absolutely vital and sometimes lose, ending the day feeling deflated and defeated in spirit. And then you vote on something that's absolutely vital and sometimes win, daring to hope to earn the right to serve and vote again. So I just wanted to thank you. Thank you for daring to try, for daring to choose, and for daring to serve. And in the spirit of gratitude, I share a few words of wisdom for the matters before you today from one of my favorite sages, Wendell Berry. He writes, "The care of the earth is our most ancient and most worthy, and after all, our most pleasing responsibility. To cherish what remains of it and to foster its renewal is our only legitimate hope. For the true measure of agriculture is not the sophistication of its equipment, the size of its income, or even the statistics of its productivity, but the good health of the land. Whether we and our politicians know it or not, nature is party to all our deals and decisions, and she has more votes, a longer memory, and a sterner sense of justice than we do." And finally, some enduring wisdom. "Do unto those downstream as you would have those upstream do unto you. Let it be so." Amen.
Thank you, Reverend. That was beautiful. Are there any announcements this afternoon? Seeing none, hearing none, we'll move to gubernatorial appointments. We have 5 appointments which we've received from the governor, which are now being referred to committees having jurisdiction. These appointments will appear in the journal, which you'll receive tomorrow. This does now bring us to the orders of the day. We've had a request to pass over S-280, and we will do so, and move to S-113. We have on the calendar for action and for third reading, S-113, an act relating to establishing a cause of action for medical monitoring and expenses. Third reading was ordered yesterday, February 2nd. Are there any amendments before third reading? Please listen to the third reading of S-113.
S-113. An act relating to establishing a cause of action for medical monitoring expenses.
The question is, shall the bill pass? Are you ready for the question? Kindly unmute.
Roll call.
The senator from Bennington has requested a roll call vote. Are you ready for the question? The secretary is kindly asked to call the roll.
Senator Ballant,
Yes.
Senator Baruch,
Yes.
Senator Benning,
Yes.
Senator Bray,
Yes.
Senator Brock,
Yes.
Senator Campion,
Yes.
Senator Chittenden,
Aye.
Senator Clarkson,
Yes.
Senator Colley,
Yes.
Senator Cummings,
Yes.
Senator Hardy,
Yes.
Senator Hooker,
Yes.
Senator Ingalls,
Yes.
Senator Kitchell,
Yes.
Senator Lyons,
Yes.
Senator McDonald,
Yes.
Senator Mazza,
Yes. Yes.
Senator McCormack,
Yes.
Senator Nitzka,
Yes.
Senator Parent,
Yes.
Senator Pearson,
Yes.
Senator Perschlick,
Yes.
Senator Polina,
Yes, excuse me, yes.
Senator Rahm Hinsdale,
Yes.
Senator Sears,
Yes.
Senator Sirotkin,
Yes.
Senator Starr,
Yes.
Senator Terenzini,
Yes.
Senator Westman,
Yes.
Senator White,
Yes.
Please listen to the results of your vote. The yeas 30, the nays 0, and you've passed S 113. We have on the calendar for second reading, S 184, an act relating to defense of others and justifiable homicide, introduced on January 4th. It was referred to the Committee on Judiciary, which reports it has considered the bill and recommends that the bill be amended as appears on pages 385 to 386 of today's calendar, and that when so amended, the bill ought to pass. Please listen to the second reading of S 184.
S 184, an act relating to defense of others and justifiable homicide.
You've heard the second reading. I'm now pleased to recognize the senator from Caledonia, Senator Benning, for the report of the Committee on Judiciary.
Thank you, Madam President. Madam President, about a year ago, this body passed a piece of legislation that dealt with correcting the justifiable homicide statute, primarily as a result of things that were taking on around the nation and leaving us with a need to make sure we had a clear understanding of what a person was able or shouldn't be able to do when it came time to protecting themselves and protecting others. One of the tweaks that we had made involved specifically identifying what a person could do to use lethal force in the event that was necessary. And we took it about a quarter step too far in hindsight looking back. What we did at the very end of the year was we had the chair of Senate Judiciary and the chair of House Judiciary write a letter to the governor explaining that we did not intend to have an impact on the common law definition of what one was able to do or not be able to do when using lethal force in the defense of another. And as we looked at the language that we had actually passed, we recognized that we should probably clean it up. So we brought a bill. And Madam President, I will have to say that after 12 years of being a legislator, this is the only time I've ever introduced a bill that had 16 co-sponsors attached to it. So many of you are already associated with this bill in one form or another. All we did when we brought the bill originally was to change a piece of language to make sure that it was understood that if you were acting in defense of another, you yourself did not have to be in imminent peril when exercising your right to protect another person when they were in imminent peril. I've used this example of the horrific event that took place on the streets of Burlington, in which a poor woman was killed by her husband on an open street. And in that instance, if I was, for instance, driving along in my car when that act was taking place, and I personally was not in imminent peril, but I got out of my car unbeknownst to the perpetrator, and I used lethal force to stop that attack, the way we had left the statute raised a question about whether or not I had the ability to exercise lethal force if I myself was not in imminent peril. So we have cleaned that language up with this bill. That was the intent of the two chairs writing a letter to the governor to make sure that we did not leave anyone with the impression that we had intended to remove someone's ability to protect another. And this bill now takes care of that. It also makes very clear in the last provision before the effective date that we had no intention and do not wish to have any impact on defenses that have been granted at common law. While we had that bill in front of us, we took a look at another provision which appears at the bottom of page 385 in the calendar, where there was language saying we could only act in defense of another if they were our spouse, parent, child, sibling, guardian, or ward. We recognize that that language is actually very archaic, and there is no rational reason in the world why you should be limited to the defense of another who is in imminent peril only if they fall into those particular categories. So this bill really does only two things. It cleans up language to make sure we did not intend to have an impact on the common law ability to defend another, and we wanted to get rid of the archaic language that you see here at the bottom of page 385 struck out. We had a number of witnesses who were all in agreement, as luck would have it. They included Eric Fitzpatrick, our legislative counsel, Evan Meenan, who is the deputy director of the state's attorneys and sheriff's department, Julio Thompson, the director of the civil rights unit at the Office of Attorney General, Matt Valerio, the defender general, Mandy Worcester, who is the executive director of policy development at the Department of Public Safety, and Judge Tom Zone, the chief superior judge for the Vermont Judiciary. Madam President, your committee voted 5-0-0, and we would hope that this body would approve the same. Thank you, Madam President.
Thank you, Senator. The question is, shall the Senate amend the bill as recommended by the Committee on Judiciary? Are you ready for the question? The senator from Addison, Senator Hardy, is recognized.
Thank you, Madam President. May I inquire of the presenter of the bill?
You may.
Thank you, Madam President. I'm wondering if you could explain to me and others for whom this may not be obvious what common law refers to and what is granted to individuals as rights under common law in these cases.
If I could put it in the easiest way I can think of, and I'm not trying to talk down to anyone. I'm trying to translate legal questions into a plain English that anyone can understand. Essentially, at common law, you've always had the right to use force against someone else. And I'm specifically talking about lethal force in a situation where you recognize someone else is being subjected to lethal force and you want to defend that person. Common law has traditionally allowed that to happen. It is not necessary for you personally to be under threat of imminent harm if you go to act to protect someone else who is. And that's what common law has always held. Somehow or other, when we were tweaking the language last year, we had a bill come out of committee that kind of clouded that conversation. And we wanted to be very clear that we had no intent of doing that, which is why the two chairs sent a letter to the governor. And this bill is an attempt to simply codify that and make sure that that's not a confusing point for future juries or jurists to have to deal with.
Okay, so Madam President, at the risk of sounding silly, there's statutory law, so there's no cross-reference here to another statute. So I'm assuming it's not in our statutes. And then there's case law, which is referring to decisions by the judiciary. And this is common law. So is common law, I know I sound silly, but is it written down anywhere? Is there some place that this is the list of common laws, or how do we know?
Well, Madam President, I think you've articulated it perfectly. Case law is common law. So
Okay.
it's literally one and the same. And I thank you for that question.
Great, thank you. I do have another question, Madam President. I realize that this is just clarifying the work that we did last year, but I am a little concerned. What if there were an instance where, and we've seen this happen, unfortunately, in recent cases where someone has actually instigated an instance where they themselves might feel imperiled, but they were the instigator of the situation that caused the peril. And then they use that situation to use deadly force, claiming that they're in peril, but it's peril that they've caused. Madam President, do you understand my question? And how would this deal with that?
I actually do understand your question, and that is primarily handled by the common law, in which cases have clarified exactly that sequence of events. At some point in time, you do lose your ability to act with lethal force in a situation where you yourself have prompted that to occur. But that is, at the end of the day, left to the decision of either a judge or a jury in an individual case. It's not codified in statute, but the bottom line is, I understand your question. It does happen that somebody who has instigated something may not be able to use it, but it's a chain of facts that lead up to the decision of whether you're entitled to it or not. And without looking at any one specific case, it would be difficult for me to describe for you exactly where in that chain of events you lose that protection. I hope I didn't sound too muddy.
That makes sense. But so in that case, there's not a necessity for us to include a sort of blanket statement that says, if you caused the trouble, you can't then use these rights. That is taken care of by case law or common law.
Yeah, I think that is adequately defined, described, and has been dealt with for a couple of centuries now as to what the boundary line is about your ability to use that defense.
Yeah, well, it's clear that it's subjective to certain juries, but I appreciate the explanation. Thank you, Madam President.
The question is, shall the Senate amend the bill as recommended by the Committee on Judiciary? Are you ready for the question? Kindly unmute. All those in favor, please say aye.
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 Those opposed, nay. The ayes have it, and you've amended the bill as recommended by the Committee on Judiciary. The question now is, shall the bill be read the third time? Are you ready for the question? All those in favor, please say aye.
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 Those opposed, nay. The ayes have it, and you've ordered a third reading of S 184. We have on the calendar for second reading today, H 679, an act relating to fiscal year 2022 budget adjustments. It was referred to the Committee on Appropriations, which reports it has considered the bill and recommends that the bill be amended as set forth on page 386 of today's calendar, and that when so amended, the bill ought to pass. Please listen to the second reading of H 679.
H 679, an act relating to fiscal year 2022 budget adjustments.
Pleased to recognize the senator from Caledonia, Senator Kitchell, the chair of the committee, to report the report of the Committee on Appropriations.
Thank you, Madam President. May I speak to the bill as well as to the amendment that's being offered?
You may.
Thank you. The budget adjustment bill is something we pass every year, and normally it is to true up spending with and appropriations with actual experience to date at this point in the fiscal year. This year's budget adjustment does more than that and actually does some appropriations that will be carried forward to really continue our work in housing and also investment in upskilling Vermont workers and to establish a program to provide some financial assistance to our dairy sector. The budget adjustment is, we have the following materials for the body to follow in. First is a 2-page summary of the adjustment itself in the Senate proposal of amendment, which has been, those changes have been identified in shading. We also have a document that helps track through the spending of the ARPA state fiscal relief money in terms of what's been spent to date and what is still available. There is the addendum as well as the web report that tracks through the actual changes, money changes, the appropriation changes by section. It's in total kind of lengthy, so our attempt is to give you the highlights. And one of the important things is that the amount of general fund involved here has been influenced by the revenue upgrades that were approved in July and January. In July, the upgrade was 190 million. In January, it was another 40.5. So that is a result really of over $10 billion of federal money coming into the state, and it has dramatically influenced the revenues flowing to state government, both in terms of personal income tax as well as consumption taxes. And so there's also been a concurrent increase of revenues into the education fund as well as the general fund. This budget adjustment has unduplicated appropriations of nearly $370 million. And one of the things that I would point out, which has been the topic, and you will see here, which is really important, is that we are setting aside and accounting for the 50 million additional one-time general fund that would be applied to the 150 million that's being held in reserve to make one-time payments in pension liabilities once that pension bill is completed by our Senate Government Operations Committee. If we the value of that pension underpayment is it reduces the amount of the amortized liability payment out into the future and helps us fund the pension package that is being developed. The areas where we're really seeing some increases, as often is the case, is in the Medicaid caseload. One of the conditions that came with a higher federal match was that we had to discontinue doing eligibility determinations. And as a result, the caseload has grown over what was estimated because those estimates assumed that we would, at this point, be undertaking eligibility determinations and would be terminating coverage for people who no longer met the eligibility requirements. So that that is an increase of about nearly $30 million of state, and it's attributable to that requirement that came with a higher federal match. We also are including over $6 million to the Office of Economic Opportunity. One of the areas that's being $5 million of that is to help with risk payment to help get families into permanent housing, and oftentimes landlords would like to have assurances of financial protection if they are renting to perhaps a family where there might be some risk around associated with the rental arrangement. We also have a variety of places where we're recognizing the difficulty of our workforce environment. The Department of Corrections, there was a negotiation of a side agreement to increase retention and hiring and shift differential to our Department of Corrections workers in our correctional facilities. That side agreement was about $6 million. Some of that could be accommodated, but the budget adjustment includes about $5 million to go with it to support those payments. We also are providing $25 million to similar to provider stabilization that we've done in the past. We know that the financial situation of some providers is rather fragile, and we want to make sure that we can address those healthcare provider needs. The other area where we are providing assistance on workforce is in another section where it's a combination of funds to total $60 million to help with workforce recruitment and retention, needs-based approach, and applications would be filed with the Agency of Human Services, and the funding would be, the level of funding to the grants would be determined, obviously, to keep within the $60 million appropriation for that purposes. The other area that the budget adjustment really focuses on is getting internal service funds deficits cleaned up. And so we have money that we are recommending be appropriated to address the correctional industry's internal deficit of almost $2 million. We are partially paying down the property management fund deficit of $5 million, but we're also allowing at the end of the year, if there's a surplus in FY 2022, which appears that that is very likely, then an additional $5 million will go to the property management deficit fund, which basically will eliminate making a note on the annual CAFR, and there's a plan to pay off the remainder. And then there's another $20 million that would be allowed for the payment to redeem outstanding bonds. The other area of payment is with the transportation infrastructure bonds, and there is about $20 million to pay off those bonds. And the advantage of doing that is then the debt service, which is about $2.5 million a year, would be available to serve as match for the federal infrastructure funding that is coming down, but does require the state to match those dollars. There was in housing, there was in the bill as passed by the other body, $20 million with no, just a straight $20 million appropriation for the Vermont Housing Incentive Program. But last year we ran into difficulties because we had the appropriation in the budget, but we had no program rules to go with it. So we are removing the $20 million that was in the BAA and appropriating it directly in S210 to fund the Vermont Rental Housing Incentive Program so that we are avoiding or not repeating the same problem that was created last year, and we're having the money and the policy travel together. Other areas that are somewhat maybe that the Senate did that was different from the bill as it came from the other body. There was a request to accelerate something, $1 million appropriation that was being recommended by the administration in the FY23 budget, but to move it into the BAA because of the timing, and that is $1 million state match that would be split with economic development administration opportunities that would include 2 jobs and another grant. We also are fully funding the cost of moving the railroad station in New Haven. That has been the topic of a lot of press coverage, and we're happy that we can preserve the historic building. And the little town of New Haven was quite worried about how that additional cost was going to be covered. One other area that we wanted to deal with a special fund deficit, and that is with the Cannabis Control Board. Because there are no revenues flowing in yet, the cost of the board and the staffing to date has no revenue to support it. It was really just, the intent was to deal with it later on and have repayment of the deficit, but we decided that we should fully fund the deficit for FY22. And the other request that we had was for 11 positions to implement the program. And there was concern that the 3 positions that were approved in the budget adjustment as it was passed in the other body did not provide sufficient staffing to really support the implementation of a whole new program and to meet all the administrative requirements that had been added by the legislature. So that is another $850 million to fully address the costs for this fiscal year, and to create the eight out of the 11 positions requested. The other area that I think is worthy of specific note is that there's $2.6 million for the dairy margin coverage program, and we believe that that could be a significant way of assisting our dairy sector of the economy. This provides payment if there's a gap between milk prices and the average feed cost, and particularly for organic farmers, the cost of feed is quite high. And the return, at least past experience has shown, is quite positive in terms of cost of the premium relative to the payment back to the applicant farmer. The other sections that I would just like to point out, and there are not so much money, but there's language, and that's section 54. One substantial area of federal funding to the state of Vermont was in the form of emergency rental assistance. It's over $300 million. Right now, those payments are going out to help reach up families with their housing costs. But in the emergency program or the transitional program that has been funded by FEMA, we want to recognize and switch over to the federal ERAP program. The reason for that is that if you don't spend the money, it will be clawed back. But in addition, by spending and meeting the spending requirements, it frees up or it gives access to about $30 million that you can, the state would be able to use for affordable housing. The area that has been a topic of some emails, and that is the funding that we did for our career and technical education centers. The administration had proposed $1.5 million that would be distributed based on average head count over several years to all the CTEs. We have 3 CTEs that are independent of LEAs, and they had made a request, and the budget adjustment as we received it had payment to those 3 centers, but nothing for the other centers. And the argument for that is the independents were not eligible for ESSER funding. On the other hand, the CTEs, in order to have ESSER funding, had to be supplicants, I guess, to their local LEA. for funding, and in many cases were not successful. So for a different reason, ended up with no funding, just different than the independent centers. So we had increased the appropriation from the education fund from as recommended by the administration from 1.5 up to 1.725, and would distribute that money according to the average head count for all the centers. There is now some discussion about the methodology we used. So we have one difference certainly there with the other body relative to how we want to provide financial assistance to the CTE community. But there's no question that they all have been impacted because COVID has prevented them from doing the student recruitment that they normally would undertake, and therefore their enrollment has suffered as a result. So I think with that, the amendment I'd like to speak to is really very technical. It's not substantive. The first is instance of amendment is that we needed to correct a date change, and that had to do with the section that has the transition to the ERAP program and deals with provision in law that would treat these rental arrangements the same as we have in general assistance. But we had a date of August 30th and it needed to be September 30th. And the second instance of amendment in listing the providers that would be eligible for the assistance for retention and recruitment assistance, we inadvertently left out shared living providers. So we rewrote and replaced that section to address that omission. So with that, those two minor changes, we would ask this body to concur. The vote in Senate Appropriations was 7-0-0. Thank you, Thank you, Madam President.
You're welcome, Madam Chair. Thank you. We have 3 questions and we'll have 3 votes. The first will be on the proposal of amendment that was just reported. And the question is, shall the Senate adopt the proposal of amendment as proposed by the Committee on Appropriations? Are you ready for the question? Kindly unmute. The senator from Chittenden, the senator from Chittenden is recognized.
Thank you, Madam President. May I inquire of the presenter?
You may.
Thank you, Madam President. Just a quick clarification, Madam President, when you presented, I believe you said the appropriation for the Cannabis Control Board was $850 million. And I'm quite sure that's not $1 million. And I would like to make sure that we get that clear on the record.
Thank you. Thank you, Madam President. Yes, it is $850,000. I do not want anyone to think that the cost of implementing the program was quite that high. So I apologize for that error on my part. And thank you for noticing that. The number is correct on the material. I was just a few digits off in my presentation. Thank you.
Thank you, Madam President. Just important, and may I say to the presenter, I don't know how you keep any of the numbers straight, let alone every one of them. So thank you. I appreciate the time.
I believe there was another hand raised. Senator from Orange is recognized.
Thank you, Mr. President. Madam President, once again.
This is twice today. I've got the jar here.
My bad habits continue. Madam President, we listened to a long appropriation, big money up, Madam President. My question is parochial. In my county, many senators have heard of a dairy farm that had wire in its fields, and its cows swallowed the wire and have died, and the farm has been obliged to buy feed for the last year and a half, and there's been no resolution to this issue. This morning, Madam President, we had an injunction. Our devotions were from Wendell Berry, of all people, on this day, and talking of the good health of the land. Yesterday, I was pleased to read the addendum to the Appropriations Bill, which the chair of the Appropriations Committee characterized a few moments ago as providing additional financial assistance to our dairy sector. I looked through the addendum for where I might find some assistance to the farm in Tunbridge that is suffering and now in a legal wrangle. Madam President, I also know that the Judiciary Committee has been looking at the issue from the farm in Tunbridge whose cows have been died and where they are buying feed. The Judiciary Committee is looking into changing the law to see that such a thing doesn't happen again. Almost like the medical monitoring expenses that we approved just minutes ago. So when I looked through the bill, I didn't see any ability of the Secretary of Agriculture to take any actions and appropriate any monies to help that farm in Tunbridge. I know that also that the Agriculture Committee has been taking testimony to try and see that how funding can be used to help that farm in Tunbridge. And I've been told both by the chair of the Committee on Appropriations that they will be considering this problem in the big bill. And the last time I offered a amendment to an appropriations bill, I went and checked on it. It was to add $4 million to the appropriations bill. So I thought maybe I would offer an amendment before third reading on this bill. But since the $4 million amendment that I offered passed several years ago, I don't want to risk my track record. So I was wondering if I might interrogate the reporter of the bill.
You may.
Madam President, could the reporter of the bill share with the senators how they are working on this Tunbridge issue and where it may be likely to show up in the subsequent big bill that the committee is already beginning to work on?
Thank you, Madam President. First of all, the 2.6 million is for a very specific purpose, and that's to fund a dairy margin coverage program. The situation that you present, I first of all have to say that the committee received no specific recommendation for funding from the Agency of Agriculture for us to consider and how that payment would be made. And therefore, this budget adjustment has no funding to address the hardship that individual farmer has experienced. I'm looking forward if the Agriculture Committee and other committees and the Agency of Agriculture can present some mechanism by which we recognize these situations, then the committee will entertain it. But in the absence of request or any other methodology around how we would determine the payment, this was not not on a topic or a request of consideration at this time. as part of the BAA. That does not mean that that work can't continue, and that if there is agreement that there is a need and a way to remedy that harm, that it can be considered as we finalize the fiscal 23 big bill in the budget for the upcoming fiscal year.
Madam President, I want to thank the reporter for her remarks, and I want to acknowledge that they have been discussed and been looking at this for some time, and I would defer to their judgment that this perhaps is not the best place at this time to tackle this issue. But I will report to my constituents that the Judiciary Committee, probably it's not their jurisdiction to be making such appropriations, that Agriculture will continue its work, and that we can expect to get a final recommendation in the big bill that it will be forthcoming. So thank you, Madam President, and thank you, reporter.
The question is, shall the Senate proposal of amendment be further amended as moved by the senator from Caledonia? Are you ready for the question? Kindly unmute. All those in favor, please say aye.
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 Those opposed, nay. The ayes have it, and you've amended the Senate proposal of amendment as moved by the senator from Caledonia. The question now is, shall the Senate propose to the House to amend the bill as recommended by the Committee on Appropriations as amended? Are you ready for the question? All those in favor, please say aye.
Aye. Aye.
Those opposed, nay.
No.
No.
The ayes appear to have it. The ayes do have it, and you propose to the House to amend the bill as recommended by the Committee on Appropriations as amended. Excuse me. The question now is, shall the bill be read the third time? Are you ready for the question? The senator from Franklin is recognized.
Thank you, Madam President. I'd like to congratulate the Committee on Appropriations, and in particular, the chair of Appropriations, who continues to amaze me every time we hear a budget or a budget adjustment act explained so thoroughly, comprehensively, and actually almost understandably. Notwithstanding that, I've heard these presentations and looked at lots of budgets and budget adjustment acts over the years, and I think in retrospect, I can't remember any that I've opposed until now. And I am opposed to this bill as it reads right now. And I hope to be able to offer first to the Appropriations Committee and to the body an amendment before third reading that may address some of my concerns. In particular, my concerns are, as I go back to the governor's budget address not too many weeks ago, in which we talked about clearly the fact that ARPA funds should be reserved for long-term tangible infrastructure projects which will transform communities and make a lasting difference to our state. And as I look at this particular bill, it looks like the House spent about 20% of the remaining ARPA funds on some worthy initiatives, but they include 20% of spending in services and programs. And that reduces the available ARPA funds for infrastructure projects to revitalize our rural communities across the state. I'm secondly concerned about the absence and removal of the provision regarding middle-income housing. And that was a $5 million for a program on creating the missing middle housing for moderate income homeowners. Although we're rightly doing a great deal to deal with low-income housing, middle-income housing is a critical problem in Vermont. And it came to me in particular just the other day. I got a call from a nurse at the Medical Center Hospital in Burlington. And she and her two children are living in Highgate, north of me, which is hard to get north of me in Vermont right now. And they're living there because that's the only place that they can find affordable housing. They can't find it nearer the place that she works, even though she gets a reasonably good income by Vermont standards. And that's a problem. I'm concerned about the Senate has removed funding for VHIP from the Budget Adjustment Act. I believe that's $20 million, and placed it in S210, which is the rental registry. And the rental registry, there's a question as to whether the rental registry will survive the entire legislative process, because it is subject of controversy in some areas. And I wonder that removing that money from the Budget Adjustment Act and placing it with the rental registry is really a wise thing to do. In terms of workforce, financial assistance, I believe, should be offered along with only a requirement that once we attract a worker, that worker should agree to work in Vermont at least for some period of time. And I think that's an important piece that ought to be added to the bill. Lastly, I'm concerned a bit about pensions and whether or not we are moving short-term one-time general fund expenses into ARPA in order to preserve the general fund for pensions, whether or not that's the best plan. And I have a real concern about that. These are the issues that concern me about the BAA as it exists right now. As I mentioned, I hope to offer before third reading an amendment that addresses some of these, and to present that to the Appropriations Committee beforehand so that they might have a chance to look at it and see if there is the potential for agreement. But thank you very much. And again, this is not by any means a criticism of the Chair of Appropriations or what Appropriations did. I think that facing the kinds of complexities that the committee had to face, I believe that they did a fine job, with the exception of the kinds of concerns that I've raised. So thank you very much, Madam President.
The senator from Caledonia is recognized, and then I'll move to the senator from Chittenden.
Thank you, Madam President. One thing that I neglected to put in terms of my remarks is that we did add language in the Senate around, if you get one of these grants, you're committing to working in that position and actually not be cannibalized from another provider, and that would require a 1-year commitment. So as the bill came over, it had no obligation to that effect. And so I apologize that I did not reference, but that was a change that we felt was important, is that there was a commitment for ongoing employment. And regarding the administration's request for the missing middle home ownership program, the committee did not appropriate the money at this time. However, because the program was viewed both in the other body and by our committee, policy committee, that it needed to have a little bit more development. So it wasn't as though there was a decision that did not have merit. It was a matter of having sufficient detail about how the program would work. And our thinking is that that would be something that we would revisit when we do the 23 budget, or if that program can be more further developed before that. We certainly are open to it, but I want to make it clear it was not a rejection, that was not a need, and that was not an area that we wanted of housing that we did not, we were not rejecting the need to address. It was simply a matter of the recommendations and the timing and the desire to get a better understanding about how the program would be designed and how it would operate. Thank you, Madam President.
The senator from Chittenden is recognized.
Thank you, Madam President. I wasn't going to talk about this, but in between raising my hand and now, the issues of some housing issues have risen, and I just want to say that I want to thank the Chair of Appropriations for reaching out to myself as Chair of the Housing Committee to ask questions about these housing programs that were clearly, in the testimony we had, very underdeveloped at this point, and would let major programs go forward with tens of millions of dollars without any guardrails on them other than a title, as we've seen in what happened with the VHIP program as well. So when you let a program go forward with tens of millions of dollars and all you have in there is one sentence in the budget bill, you're really emasculating the legislature. You're taking us out of the picture and just letting the administration design a program, and the details of a program could be far more important than just the goal and the name. So I assume we'll have this debate tomorrow again, but you have a preview of it now. And I'd like to interrogate the reporter of the bill, if I may.
Yeah, you may.
Thank you. This, Madam President, I'm not sure this is a fair question, and I'm not sure I fully expect an answer, but sometimes we learn on bills that are going over to the other body whether they have a clear indication of whether they may be accepted by the other body in total, or there's likely to be a conference committee. And I'm just trying to get a feel of the timing of things here, and if the chair has an idea on this or wishes to share it, I'd like to know if she knows whether we're going to conference or not.
Thank you, Madam President. I cannot answer that question. We have not had any discussion around whether we can have maybe concur with further amendment or not with the other body. I think on the whole, the differences in the bill between the two versions are not substantial. Generally, we have wanted to do more to clean up our bill, to clean up deficits, and use general fund to do that. I think that certainly the use of ARPA money, we did not change that. I know that there's a difference of how you define what should be used for, or what's transformative, or what preserves the current capacity and structure. So I certainly appreciate that. But in terms of how the differences between the House passed budget adjustment and what we are proposing, if it would necessitate a committee of conference, I can't answer that question at this time.
I appreciate the answer. Thank you very much, Madam President.
The question is, shall the bill be read for the third time? Are you ready for the question?
Ask for a roll call, Madam Speaker.
The senator from Franklin has requested a roll call vote. Are you ready for the question? Again, the question is, shall the bill be read for the third time? The secretary is kindly asked to call the roll.
Senator Ballant.
Yes.
Senator Baruth.
Yes.
Senator Benning.
No.
Senator Bray.
Aye.
Senator Brock.
No.
Senator Campion.
Yes.
Senator Chittenden.
Aye.
Senator Clarkson.
Yes.
Senator Collymore.
No.
Senator Cummings.
Yes.
Senator Hardy.
Yes.
Senator Hooker.
Yes.
Senator Ingalls.
No.
Senator Kitchell.
Yes.
Senator Lyons.
Yes.
Senator McDonald.
Yes.
Senator Mazza.
Yes.
Senator McCormick.
Yes.
Senator Nitka.
Yes.
Senator Parent.
No.
Senator Pearson.
Yes.
Senator Perschlick.
Yes.
Senator Polina.
Yes.
Senator Rahm Hinsdale.
Yes.
Senator Sears.
Yes.
Senator Sirotkin.
Yes.
Senator Starr,
Yes.
Senator Terenzini,
No.
Senator Westman,
Yes.
Senator White,
Yes.
Please listen to the results of your vote. The yeas 24, the nays 6, and you've ordered third reading of H 679. We have on the calendar for today S30, an act relating to prohibiting possession of firearms within hospital buildings. The House has proposed to the Senate to amend the bill as set forth on pages 386 to 392 of today's calendar. The underlying question is, shall the Senate concur with the House proposal of amendment with a further proposal of amendment? The senator from Chittenden, Senator Baruth, is recognized for the proposed amendment. Senator, kindly unmute.
Thank you, Madam President. Can you hear me all right?
Yes, and a slight rewind if you don't mind.
Well, that was the question that I asked.
You're clearer now. Thank you.
Okay, thank you so much. S30, senators will remember we passed out of this body about a year ago, and it has had a slow ride, but to their credit, our colleagues in the other body picked it up very quickly this session and did, I believe, their customary careful work. And so the Judiciary Committee comes to you today with a further proposal of amendment, but it is purely technical in nature. It's really just fixing an ambiguity in the drafting. My colleague from Windham, Senator White, pointed out a problem which we believe we have fixed. Madam President, may I speak both to the House language and the proposed amendment?
You may.
As was said, if senators look at page 386, you'll be able to follow along with, there are 6 sections. And I want to stress at the outset that for the most part, these are things the Senate has already passed in a previous bill, S169. That was the waiting period bill, and it had a number of components. That bill, unfortunately, was vetoed by the governor. But what the House has done is to forward half of S30, which is the ban on firearms in hospital buildings. They did remove the study around weapons in the Capitol complex, but they have given us back the ban on firearms in hospitals as we passed it out, with one change, and that is that in our version, we had a fine and up to a year in prison as the penalty. They have kept it as a criminal offense, but it has a flat fine of $250 under this section without reference to jail time. Other than that, it is as senators saw it go out last year. I will skip over section 2 because that's where our amendment comes in, and I'll leave that for the end of my quick presentation. So if we could move to section 3. Sections 3 and 4 have to do with our ERPO law, which stands for Extreme Risk Protection Orders. And that's a process that we created in 2018, and it authorizes certain prosecutors to petition a court for an order preventing a person who poses a risk to self or others from accessing firearms. And that, I believe, has been operating well, that law, but some medical professionals believe that they are a little leery about using their authority under HIPAA to report under the ERPO law. So in other words, if they have a patient that they believe represents an extreme risk to themselves or others, HIPAA, the federal law, does allow them to report to a prosecutor, but they remain a little leery. And so Section 3 clarifies, using language straight from HIPAA, that they have the ability to report in those cases. And they can, in that way, contribute to the issuing of an extreme risk protection order. Section 4, bottom of 389, is a report. We have also passed this out before. And the idea is to gather data on these extreme risk protection orders, have it come in annually, and go to the relevant committees. And it allows us to do a number of things to see how many were issued, geographical data, follow-up information on whether the order was renewed and terminated. And also, you'll see there at the very end, this data will allow us to do more work on suicide profiles and hopefully generate the data necessary to, in the future, target our troubling suicide rate directly. So this is all useful data that will come in on an annual basis. Section 5, if senators will remember, in S55, which the governor signed some years back, there was a ban on large capacity ammunition feeding devices. And in that law, there was a sunsetted provision that made an exception for these feeding devices that were going to be used by out-of-state contestants in Vermont state shooting contests. And what it said is, if you acquired one of those high-capacity magazines out of state lawfully, and you were only bringing it into the state for the purpose of the competition, that was okay under S55. That did sunset. And if senators will remember, our former colleague, Senator Rogers, I think of this as the John Rogers piece of this bill, because this was originally proposed by Senator Rogers. It was included in S-169 and was part of the vetoed bill. Before I leave this, I just want to have senators take a look at that actual language on 390 at the bottom. It's very carefully written, and the House added a piece that makes it even more carefully written. So this is an exception that applies as follows. For a feeding device transported by a resident of another state into this state for the exclusive purpose, and I would hit hard the word exclusive, of use in an organized shooting competition, sponsored, and here is their new language, sponsored by an entity registered with the Secretary of State if the device is lawfully possessed under the laws of another state. So there was concern that there might be some slippage in the language that would allow people to either create a bogus contest or under the pretext of competing, unlawfully possess these devices. I believe the language the House came up with is very tight in that regard. And then if you go to Section 6, this has to do with not ERPOs, but emergency relief from abuse orders. And this clarifies existing practice. So we are not breaking new ground here. We had testimony as recently as this morning from Judge Zone, who believes that judges now believe that under statute and within the Constitution, they already have this power. And what it involves is when someone who believes that they are subject to imminent abuse, they can petition the court for certain remedies, and you see them listed there on page 391. This clarifies and codifies that one of those remedies, which again is already being done, is to relinquish firearms for a 14-day period until a hearing can be held, and then at that hearing, it could be extended to a permanent order, or the order could be allowed to lapse and the firearms restored to the person who had them removed. I will, if I could, go back to section 2, and this would be page 387. Section 2 begins there. This is what is commonly referred to as closing the Charleston loophole, or eliminating in legal terms what's known as the default proceed. So under federal law, when you go to buy a firearm, you have to get a background check. Under federal law, if the background check doesn't come back within 3 business days, there is a default proceed and you can get the weapon anyway. You don't necessarily have to be sold the weapon, but you can get the weapon after 3 days. Now, there's an obvious problem given that if a background check doesn't come back, it generally has to do with the fact that the FBI is investigating why it didn't come back clean. So 90% of these background checks come back within minutes. 97% come back within 3 days. Of that remaining 3%, they are 4 times more likely to be involved with domestic violence and domestic abuse. And so when somebody's background check doesn't come back within 3 days, it's a good likelihood, in other words, that they may have issues that really should mean that we don't want them to have a weapon. So closing the Charleston loophole involves saying that someone who has not passed a background check cannot get a weapon, period. Now, the problem I mentioned earlier, if senators will look at the next page, 388, the language the House put in to close the Charleston loophole specified a day after 30 days. So their language said, the licensed dealer facilitating the transfer is not provided with the unique identification number, provided that if the identification number has not been provided within 30 days, then the transfer may proceed. Now, under federal law, it cannot proceed after 30 days because background checks only last 30 days. And this led some people to talk about what they were calling an endless loop given this 30-day period. But really, the 30 days would simply close the loophole that we call the Charleston loophole completely. But to remove the confusion, what the Judiciary Committee did was to go back to the language that we had originally in the waiting period bill that passed out of here and the House in S-169. And if senators will look at the proposal of amendment, I believe that was emailed to them. It's also on the Senate's landing page. You will see there that the way we've framed it now, and the whole subsection is listed there, D, a person shall not transfer a firearm to another person if the transfer requires a background check under this section or under federal law, and 2, the licensed dealer facilitating the transfer has not been provided with a unique identification number for the transfer by the National Instant Criminal Background Check System. In other words, if your background check is not complete, you cannot go ahead with the sale, and that is a complete and total closing of the Charleston loophole. So with that said, Madam President, I will only say that this bill has had a long road. It now has one more stop, which is back to the House, hopefully that they will concur with that purely technical amendment, which doesn't change their intent or our intent, just clarifies the drafting. The last thing I will say is that a bill like this doesn't proceed through our chamber and the other part of the legislature without very clear direction and leadership from the chair of the committee and our Senate President Pro Tem. And I want to specifically thank both of them, as well as my committee, for their careful work. With that said, our vote to concur with this technical proposal of amendment was 4-1-0, and we hope the Senate will concur. Happy to answer questions.
Thank you, Senator. The question is, shall the Senate concur with the House proposal of amendment with a further proposal of amendment as proposed by the Senator from Chittenden? Are you ready for the question?
Roll call.
The Senator from Essex Orleans has requested a roll call vote. Again, the question is, shall the Senate concur with the House proposal of amendment with a further proposal of amendment as proposed by Senator Baruth? The Senator from Washington is recognized.
Thank you, Madam President. May I inquire of the presenter?
You may.
Thank you, Madam President. I noticed that when in your presentation you said that the bill you dropped the jail time from the potential proceedings around the hospital, the guns in the hospital. Does that mean that there can never be jail time, or what would we expect to, I would assume jail time would come into play at some point. I'm just wondering when that would be, if you know.
I thank the Senator. That was a provision that was modified by the House. We are going along with it. On my part, personally, I would say I'm going along with it somewhat reluctantly. But it was part of their deliberations and their process of compromise. I will say that the language as it stands now helped us get stronger support in our own committee. And so there was a silver lining there. Back to the question of, could someone be given jail time? Under this particular provision, somebody is committing a crime, but the penalty would be limited to the fine. There are on the books a few other offenses like this, criminal offenses that have simply a penalty. So if somebody committed no other crime, they would not be subject to jail time. But in the course of their time in the hospital, it might be that they would break some other statute, but under this one, it would be limited purely to a fine.
Thank you, Madam President.
Senator from Chittenden is recognized, and I see that the Senator from Windsor has his hand up, and we'll go to you next, sir.
Thank you, Madam President. May I inquire of the presenter of the bill?
You may.
Thank you. I am particularly heartened to see the inclusion of the Lautenberg Amendment again, which ensures that when there's a domestic violence situation, the firearms are removed in the case of an order. As the former legal advocacy director at Steps to End Domestic Violence, I was in family court a lot over those situations, and it was really critical that we allow people to know their rights and potentially get the firearms removed from a situation. Often, a protection order can escalate someone's behavior rather than de-escalate their behavior, and access to firearms is incredibly dangerous. When we looked at upholding the Lautenberg Amendment in past iterations of this bill, a major loophole was created that allowed for an affidavit to be presented that the firearms could simply be stored with a family member. That's also a very dangerous situation for someone. And I just want to make sure that that loophole is being closed in this bill, so you no longer can simply leave the firearms with a family member and consider that safe enough in a domestic violence situation.
I will read the language in what we're putting in here. Again, this is current practice that the possessor of the gun must relinquish the firearm. So we did have testimony on whether someone should merely be required under statute not to possess. But in this case, it says they must relinquish it. So the language on 391 reads, to immediately relinquish until the expiration of the order all firearms that are in the defendant's possession, ownership, or control, and to refrain from acquiring or possessing any firearms. I don't believe that it remains a possibility for, and I will defer to the chair of Judiciary if he knows more about this. I don't believe that under this, you could relinquish it to a friend or a family member. I believe what it means is that law enforcement removes the weapons, under bearing the order, and take them away. And I would defer to my colleague from Bennington.
The senator from Bennington, the chair of the Judiciary Committee, is recognized.
Madam President, I'm not sure that my answer would be the one that the senator is looking for. I believe that it's still allowable, and it's up to the judge where the firearms are relinquished, and that's a whole different statute that I'd have to look at regarding firearm storage. As you know, we've had tremendous problems in the state with firearm storage. We even had bills a few years ago, basically just on storage of firearms. So it is a problem for local police departments. They don't have the space. So I think that it's still allowable, but it's up to the judge if they determine that the person who's they're relinquishing the weapons to is responsible.
Madam President, I'll just add, I received a note that says, I believe Senator Sears is right about final orders, but under these 2-week emergency orders, they cannot be stored with a third party. So at the hearing, if I have my understanding correctly, at the hearing after 2 weeks, an arrangement could be made to store with a third party. But the senator from Burlington, I believe your concerns should be satisfied by this piece of the statute, because under the emergency order, they cannot be stored with a third party.
Thank you, Madam President. I unfortunately, my concerns aren't satisfied, because I always saw this as a potentially dangerous situation. In many cases, a family member can be complicit in saying that, somebody just wants to go hunting, or they just want to go shooting and they want access to their gun. And I've always seen this as a really dangerous loophole in the law. So I may raise this concern again with the Senate Judiciary Committee before third reading.
I believe there will not be a third reading, Madam President.
That is correct. There's no third reading on this bill.
But I hear the senator's concern. I think it's fair to say that in the gun safety realm, there are a number of things, maybe limitless, which this bill does not address. I will personally make it my own agenda to add the senator's concern for the ongoing part of this year, and if I'm elected again next time out.
I appreciate that. Thank you, Madam President.
Before we move to the senator from Windsor, I'm going to ask senators, if you have calendars open or emails open and you're getting notifications, please close those tabs or please mute yourself. We're getting a lot of feedback today. The senator from Windsor is recognized. Senator, kindly unmute.
Yes, thank you, Madam President. I wonder if the reporter can answer. It's one question, and I ask it more as a matter of due diligence. I hear not all of my constituents support this bill, and they raise a particular complaint that I would like to at least address before, as I expect, I'll vote for the bill, but I don't want to ignore my constituents. What steps must be taken for the 14-day duration of the confiscation of firearms to be extended beyond 14 days?
Madam President, is the senator talking about the relief from abuse order in section 6?
The so-called red flag provisions, that if someone is deemed a threat to himself or herself or others, that we disarm them for a period of 14 days, which has always struck me as simply a matter of prudence, a reasonably prudent protection of public safety or just of a troubled person. But I hear the claim made by at least some of my constituents that actually goes beyond 14 days and that people are essentially subjected to a penalty without due process. And I'd just like to know what.
I take the senator's question. There has to be a hearing. There has to be due process. And 14 days is the maximum. The person who has their firearms has to relinquish their firearms. That person can petition for an earlier hearing. So if the court can schedule it, they can get a hearing before 14 days. But that 14-day hearing is really the most substantial part of the due process that's going to be afforded. So they're given notice of the hearing. They can be represented at the hearing. The emergency RFA is issued on the basis of an affidavit that contains elements that the person submitting it swears to be true. So the court is using discretion based on that sworn affidavit to declare the emergency period. But then there is a very much standard hearing at 14 days. And at that hearing, everybody can be represented by counsel. Different views of the evidence can be argued. And at that point, then the court issues or doesn't issue a permanent order. And the permanent order, if senators look on 391 of the calendar, you'll see some of this language. This is from 15 VSA 1104. And I'll just read, if I may, from a little of this. 1, upon a finding that there is an immediate danger of further abuse, an order may be granted requiring the defendant to refrain from abusing the plaintiff and his or her children. Down below, to refrain from interfering with the plaintiff's personal liberty, to refrain from coming within a fixed distance of the plaintiff, to refrain from contacting the plaintiff, and then what we are clarifying, the existing practice, to immediately relinquish the firearms. But all of those are subject to an evidentiary hearing and with counsel, so full due process.
Madam President, I thank the senator from Chittenden.
The question is, shall the Senate concur with the House proposal of amendment with a further proposal of amendment as proposed by Senator Baruth? There has been a request for a roll call vote. Are you ready for the question? The secretary is kindly asked to call the roll.
Senator Ballant.
Yes.
Senator Baruth.
Yes.
Senator Benning.
No.
Senator Bray.
Yay.
Senator Brock.
No.
Senator Campion.
Yes.
Senator Chittenden.
Yay.
Senator Clarkson.
Yes.
Senator Collymore.
No.
Senator Cummings.
Yes.
Senator Hardy.
Yes.
Senator Hooker.
Yes.
Senator Ingalls.
No.
Senator Kitchell.
Yes.
Senator Lyons.
Yes.
Senator McDonald.
Yes.
Senator Mazza.
No.
Senator McCormick.
Yes.
Senator Nitka.
Yes.
Senator Parent.
No.
Senator Pearson.
Yes.
Senator Perschlick.
Yes.
Senator Polina.
Yes.
Senator Rom Hinsdale.
Yes.
Senator Sears.
Yes.
Senator Sirotkin. Senator Sirotkin.
Yes.
Senator Starr.
No.
Senator Terenzini.
No.
Senator Westman.
No.
Senator White.
Yes.
Please listen to the results of your vote. The yeas 21, the nays 9, and you've concurred with the House proposal amendment with further proposal of amendment as proposed by Senator Ruth. This completes the orders of the day. Just want to make sure Senator White, did you wish to be recognized?
I had thought we were going to take up H693 and remove it from I don't know when the appropriate time is to do that.
Now would be the appropriate time to do that. The senator from Windham is recognized.
So this senator from Windham or the other one?
The senior senator from Windham.
Thank you, Madam President. At this time, I ask that H693 appearing on the calendar, the notice calendar, be removed from the notice calendar and placed in all remaining stages of passage. I believe that's the right motion.
Going to slightly amend your motion. The senator for Windham has moved that the rules be suspended and H693, an act relating to the annual budget vote of the Northeast Kingdom Waste Management District, be taken up for immediate consideration. Are you ready for the question? All those in favor, please say aye.
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 Those opposed, nay. The ayes have it, and you've suspended the rules and will now take up H693. We now have for action H693, read for the first time on January 28th. It was referred to the Committee on Government Operations, which reports it has considered the bill and recommends that the bill ought to pass. Please listen to the second reading of H693.
H693. An act relating to the annual budget vote of the Northeast Kingdom Waste Management District.
I'm pleased to recognize the senator from Rutland, Senator Colley, for the report of the Committee on Government Operations.
Thank you, Madam President. The Senate Secretary sent the language by virtue of email, and it's also on the Senate overview page. And by way of background to this bill, last year, the legislature passed H48, which allowed towns flexibility in conducting town meetings. And this year, a similar bill was passed, S172, which allowed similar flexibility. One thing H48 contained that S172 did not contain was a provision for the Northeast Kingdom Waste Management District budget vote that allows the NEK WMD Board of Supervisors to approve the annual budget instead of the typical town meeting day vote by Australian ballot. The Senate Government Operations Committee understands that already 2 member towns have announced that they will change their meeting dates. It's anticipated others will follow suit, and the district is respectfully requesting that the similar provision that we voted on last year be included again this year. And the Senate Government Operations Committee simply viewed this as an oversight when we passed S172 earlier this year. Committee vote was 5-0-0. We heard from Ledge Counsel Tucker Anderson, and we asked for full concurrence of the body. Thank you, Madam President.
Thank you, Senator. The question is, shall the bill be read the third time? Are you ready for the question? Kindly unmute. All those in favor, please say aye.
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 Those opposed, nay. The ayes have it, and you've ordered third reading of H693. Senator from Windham is recognized.
Thank you, Madam President. This time I ask that the rules be suspended and that H693 be placed in all remaining stages of passage.
The senator from Windham has moved that the rules be suspended and H693 be placed in all remaining stages of passage. Are you ready for the question? All those in favor, please say aye.
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 Those opposed, nay. The ayes have it, and you suspended the rules and placed at H693 in all remaining stages of passage. We now have for third reading, H693, Are there any amendments before third reading? Please listen to the third reading of H 693.
H 693, an act relating to the annual budget vote of the Northeast Kingdom Waste Management District.
You've heard the third reading, and the question is, shall the bill pass? Are you ready for the question? All those in favor, please unmute and say aye.
Aye.
Aye. Those opposed, nay. The ayes have it, and you've passed H 693. The senator from Windham is recognized.
Thank you, Madam President. At this time, I ask that the rules be suspended and we message our actions on H 693.
The senator from Windham has moved that the rules be suspended and H 693 be messaged to the House forthwith. Are you ready for the question? All those in favor, please say aye.
Aye.
Those opposed, nay. The ayes have it, and you've suspended the rules and message H 693 to the House forthwith. I believe we're now ready. Yes, the senator from Windham is recognized.
Madam President, at this time, I ask that the Senate stand in adjournment until 11:30 a.m. Friday, February 4th.
The senator from Windham has moved that, subject to any announcements, the Senate do stand in adjournment until Friday, February 4th at 11:30. Are there any announcements this afternoon? The senator from Addison is recognized.
Thank you, Madam President. Senate Natural Resources and Energy will meet tomorrow morning at 8:30.
The senator from Washington is recognized.
Thank you, Madam President. Senate Finance will meet at 2:45.
The senator from Windham is recognized.
Thank you, Madam President. Senate Government Operations will meet in 10 minutes, and warning to the committee, this will constitute our afternoon break.
Are there any further announcements? The senator from Bennington is recognized.
Thank you, Madam President. Senate Education will meet 10 minutes after the fall of the gavel.
The senator from Caledonia, junior senator, is recognized.
Thank you, Madam President. Much to the great disappointment of my committee, our witnesses and institutions have abandoned us this afternoon. So we have rescheduled them for next week, and we will not be meeting this afternoon.
The senior senator from Caledonia is recognized.
Senate Appropriations will meet at 3 o'clock, please. Thank you.
Thank you. The senator from Windsor is recognized.
Thank you, Madam President. Today is somebody we don't get to see while we're not on the floor, and who we appreciate daily when we're in person, but who we see seldom as we work remotely. But today is our Senate Secretary, staff member Steve Marshall's birthday, and we all are so grateful for his work, unseen but not forgotten.
Thank you, Senator. Are there any further announcements? The senator from Windham has moved that the Senate stand in adjournment until Friday, February 4th at 11:30. Are you ready for the question and for some lunch? All those in favor, please say aye.
Aye. Aye.
Those opposed, nay. The ayes have it, and the Senate stands adjourned until Friday, February 4th at